We're going to talk just briefly about criminal law. Again, criminal law is unfortunately a reality of business. There may be some criminal prosecution that hasn't happened yet. There's a big Wells Fargo scandal with 5,300 employees laid off. As you know, the president of the company resigned and agreed to pass on some $40 million in bonuses that he might have earned. So he'll have to slink off into the sunset with only $5 or $10 million a year. $4 million. So anyway, there's a variety of criminal prosecutions. We just want you to know the basic terminology. Malum and se are crimes that are bad on their face, like killing somebody or kidnapping or beating somebody up, stuff like that. That's pretty obvious that they're bad things. We don't have to get into a lot. As business people, we're often more concerned about malum in prohibitum, meaning that the law has defined it as something that's against the law. And so that's what we're more concerned about is like environmental regulations, or you can't have gambling in a state because the state has decided that you can't have gambling, not because it's inherently evil, depending on your viewpoint, of course. Keep in mind the plaintiff in a criminal prosecution, the prosecutor is the state. And of course, usually we have a district attorney, we have various assistant district attorneys. And of course, at the federal level, we have a similar pattern. We have an attorney general in the United States. Each area has an attorney general, federal attorney general, assistant attorney general appointed. And of course, occasionally we have special prosecutors. The approach is often is an indictment by a grand jury. That is not required. That does not happen in all crimes. If the police see you do something, they may skip the grand jury step because it's so clear, all that. But if there's no witness or it's a more complex situation, then the facts are presented to the grand jury. Grand jury is a very odd system. You're not allowed, as a defendant, you're not allowed to have your attorney in the room when you're with the grand jury. Grand juries are conducted in secrecy. You don't know who's on the grand jury, and the people are paneled for usually a month at a time, something like that. And there's some fair amount of controversy about the grand jury system. Aggressively, there's more and more concern that maybe it's not such a great system. But right now, like I said, we have two systems. One is direct indictment, and that's usually where it's a real obvious situation, and then the grand jury. Where we've seen grand juries cause some controversy have been in some of these very unfortunate killings involving law enforcement officers and civilians being killed. And a lot of times, rather than the DA saying, well, we're not going to charge this policeman, they will go and submit it to the grand jury, and then they say, well, the grand jury looked at the evidence, and they decided not to indict him, and it's a way for politically elected people like district attorneys to kind of stay out of the the pressure of not having prosecuted somebody or decided to prosecute somebody. Burden of proof. One of the things I want you to think about, many of you are familiar with the scales of justice, and it's a very classic example to think about the burden of proof. Is in criminal cases in the United States, by Constitution, we have a burden on the prosecutor beyond a reasonable doubt. And if you'll picture the scales of justice, it means the scale of justice in favor of conviction is down here. There's so much weight on it, the scale is all the way to the bottom, beyond a reasonable doubt. Now, in civil cases, the burden is much different. It's called the preponderance of the evidence. And probably the only time in your life you're going to hear the word preponderance is when we're talking about the burden of proof in civil cases. Very specific to civil cases. And what that means is the winning side in a civil case, the scale only needs to be a little lower on the winning side. So that's preponderance of the evidence. This is beyond a reasonable doubt. Okay? So it's important you see the two. Classic example of that is the O.J. Simpson case. Most of you were not born or were youngsters when O.J. Simpson had his famous ride in the white Bronco and was locked up in jail. Very terrible crime. Nicole Simpson and the wife, mother of his 2 children. And a friend of hers, Ron Goldman, who was not a date. He was not there for amorous reasons. Ron Goldman was a platonic friend for sure. We know that for absolute. But in any event, they were at her house, and somebody broke in. O.J. Simpson accused of the crime. They were slashed to death. There was not a lot of direct evidence, and but you know, oftentimes in cases where a couple is divorced, if they're married, you look at the spouse, as you know from all the TV crime shows, and if they're divorced, you especially look at the former spouse, especially if they're paying alimony or child support or whatever it is. So one of the accusations, which was brought home at trial, a very dramatic trial, a big team of lawyers working for Simpson, some of the best known names. One of them, by the way, is this, the fellow who promotes LegalZoom. He was one of the attorneys. Johnny Cochran became very famous as a result of the case of Victory, though it was a criminal case. He went and started a chain of civil law firms around the United States that had his name on them, even though he could only be in one place at a time, and did very well for a brief period of time, and then died very young, died like 50 years old. So probably most best known person out of the O.J. Simpson trial didn't get to take, you know, made a lot of money in a short period of time, but didn't get to really take advantage of it. However, subsequently, especially driven by the Ron Goldman family, Simpson was prosecuted or was sued in civil court, where he lost a $34 million judgment, and that judgment still tends against him today. It's not dischargeable in bankruptcy, this type of award. And so again, you see the difference. Preponderance of the evidence was enough to persuade a jury that he had indeed killed these 2 people, but was not enough evidence to persuade people that he had killed them in criminal court due to the difference in burden of proof. So a pretty interesting case. And that's very rare, because usually you do the criminal case first, and if you win the criminal case, it's pretty much a slam dunk to go into the civil case. But again, it's a classic example that that's not absolute in order to do that, but just point out the difference in the burden of proof. One of the very famous aspects to criminal law is double jeopardy. It's a very famous old, I don't know if black and white movie or not, very famous movie about double jeopardy is, and in fact, Simpson, bringing Simpson back up again, to make money, he wrote a book called Suppose I Did It, which I would not have recommended that to him. But in any event, he can't be tried for the crime again. So he writes a book called Suppose I Did It. His problem is that he has a $34 million judgment against him that draws interest every day, every month. So as soon as the book came out, the Ron Goldman family, again, tend to take the lead over the Simpson family, the Nicole Simpson's family, went to court and established that if there were any proceeds from the book, they would go to satisfy the judgment and would not go to Simpson. Now, many of you may be aware that he is in jail right now for attempted armed robbery, and he's in jail, I think in Nevada. I think he broke into a hotel in Las Vegas and claimed that some of these sports memorabilia actually belonged to him and could not be sold by this vendor at some sports memorabilia show. Part of the problem with this is, not only was it an insane thing to do on its face, but the point is, if there were memorabilia there that belonged to him that were still had value, they would belong to the Goldman-Simpson estate. Nothing that he owns belongs to him anymore, unless, except, and you say, but Simpson, before he went to jail, lived like a rich guy. He was out playing golf and partying in Florida a lot and all that. How did he do that?
Money to somebody else's name?
NFL pension. And what we're going to cover in the employment chapter is something called ERISA. The Employee Retirement Income Security Act of 1974 says that your pensions cannot be attached by your creditors. They're protected from your creditors, including in that pays. So he gets a pension check every month from the NFL, National Football League Pension Fund, and that money cannot be attached until it hits his bank account. So I was talking about this at lunch. I went to a bankruptcy lecture at lunch today, and what I anticipate is he probably moves that bank account that the money goes into every year, every month or two, because otherwise it can be attached. So he can't be attached in the fund, but when the check is written to him, it then becomes money that's available to his creditors. So it can be kind of interesting there. So we look at different types of crimes. There are three categories. Treason is the most serious crime, followed by felonies, and then followed by misdemeanors. And misdemeanors, jail less than a year and or fine. And treason. Treason's a technical issue because a lot of people felt that Snowden, in his disclosures of NSA spying and so forth, committed a treasonous offense because he acted against the government. The problem with that is that we're not technically at a declared war. So to commit treason, you have to help the other side in a war against the United States. Technically, he didn't really do that. So he did violate national security laws, but he may not meet certain standards to actually commit treason, which is punishable up to death. Administrative crimes, again, is where we're more focused as business people, malum prohibitum. And so we deal with that. And there's a sad thing happening right now. It's actually mentioned in an article in The Economist, of all places, several months ago, that talked about the fact that the trend in the United States is for these administrative agencies to bring criminal charges in what most of us business people consider civil issues. And so, unfortunately, increases the pressure on us as business people. And it may mean more and more businesses have to hire criminal defense attorneys, when normally, in my career, long career, very, very rare instance to deal with a criminal prosecution. We call white-collar crimes generally that do not involve physical injury and generally involve money like embezzlement and stuff like that. Fraud is a big deal, obviously, but keep in mind, fraud is not just somebody saying something that's not true to you. You actually have to reasonably rely on the fraud. So somebody has to put together a good enough story. So if you're careless and you get into a business deal, you can't allege criminal fraud just because you were careless. You have to show that the other side presented a case that was reasonable enough to you that when you relied on them and you lost money or something like that, that indeed you were acting reasonably and not outside of your premise, outside of normal business bounds. Keep in mind, forgery. It's writing somebody else's name on a check. Forgery, very common. Also, embezzlement, which is accessing funds that you have access to. And so we see a lot of that, unfortunately, in business today. White-collar criminals generally got light sentences, and the book mentions, of course, Bernie Madoff. Madoff got 150 years, although he is at Club Fed, as they call it. He is at a low-security facility, and that was part of his plea bargain, is that he was going to go to a particular place for his jail time. He also, I think, pled early and quickly because his sons and his wife were as guilty as he was, and his wife got to keep $2 million in the condo in New York City, and his sons didn't go to jail. So I think he got a better deal than he deserved, and the public did not get as good a deal as they deserved. Enron, one of the more interesting criminal prosecutions. Ken Lay had been the CEO of Enron when Jeff Skilling, the president, resigned. He was president and CEO when the company collapsed. He made a lot of money while the employees of the company were frozen out of the 401k. Most of them had all of their money in their 401k in Enron stock. The stock went up to the $60 range, dropped to 20 cents a share before the company filed for bankruptcy. these people, these employees that they had their money in the 401k plan, basically lost all of their savings in addition to losing their job. Very sad situation. There's a certain poetic justice. Ken Lay's found guilty of fraud and stock manipulation and so forth. He's sentenced to prison. And for most of us, we would have been held off in handcuffs, right? Straight to the jail. Ken Lay gets to go home until sentencing. Gets better. He goes to his condo in Aspen, Colorado. Okay. Where he drops dead from a heart attack. Now, the reason I say there's poetic justice to this is that Ken Lay wasn't that old. He was like 60, 65, whatever. He probably would have been released from prison before he passed away. But since he was in Aspen by himself instead of in a prison cell where people could look at him and say, gee, we better call the EMT, he didn't make it. But I mean, it's a bizarre thing when you see the irregularity of the law is that, you know, any of us in this room convicted of a quarter of the crime would have been hauled off to jail immediately, and he gets to go wander about. So, pretty interesting, but something to think about there. As I mentioned, you can be prosecuted in both criminal and civil court for many different types of crime. Now, you're going to see this term prima facie a lot in studying the law and business law. Prima facie is a Latin term that just means making the case. It's having all of the elements that you need to argue your case or present your case. Now, here's an important concept behind a prima facie case. It doesn't mean you're going to win, but it means you should survive an early summary judgment or motion to dismiss. So you've at least articulated all of the elements that you need to win. It doesn't mean you can prove all of those elements, but you have to at least start by having them all on the list. And we'll point that out as we go through each type of claim. Speaking of white collar, we had to have a way to combat the mob, and RICO is that statute. It's been around for a while now. It's been used to prosecute a lot of the gangsters up there in New York, New Jersey, and Houston. But what happens is that it is not. It has not been found to be exclusively limited to gangsters, and it is increasingly being used against business executives like Ken Lay or Marty Madoff. So kind of interesting. So the application of RICO has been expanded beyond the original intent to go after gangsters. Wire fraud, big example today is a lot. Almost everything done by email and telephone and all that comes under the wire fraud concept, and that's prosecuted as well. So you see a lot of different arguments. The slides mentioned, of course, the hypothetical example that many of us have gotten the Nigerian land offers and other weird things. Just about once a month I get one of those emails from somebody. It's a spoof email, and it lists a real person that I know, and it says, hi, you know, I'm embarrassed to say this, but all my money's gone. I got mugged while I was visiting in Spain, all this stuff. So what I do is, since there's a real person involved, is I forward the email to the real person and say you might want to change your password from being spoofed and all that. Very sad story. You think none of us were stupid enough to fall for that. Doesn't mean your parents aren't. And I was at a lunch meeting with some people that I just barely knew, outsiders, and they were telling me that their parents thought that a cousin of theirs had contacted them from California and said, hey, you know, I'm being held and I have to pay these people money and all this stuff. And they actually sent $8,000 or $9,000. Of course, it's always done in cash, and so there's no way to find the people or recover it because it's just physically handed to people. I've actually heard a real case where that was done. It's very sad. So we mentioned that RICO is some of the targets, looking at income from racketeering, acquiring, maintaining an interest in an enterprise of racketeering, and conspiring to do these things. Keep in mind that private parties can bring RICO actions. Not a lot of that happening out there. You might have seen a civil action against Madoff's estate for alleging RICO and stuff like that, but it's not really done a lot. Most of it's public prosecution. Keep in mind that you have to intend in many cases to commit the offense that you're accused of. You have to form mens rea, the mental intent to commit crime. But there's tons and tons of exceptions today, unfortunately, including us as business people. It's almost assumed if we're doing business, for instance, you have a truck breakdown, something bad happens, and there's some bad stuff in the truck on the way to proper disposal. The truck gets run into and there's bad stuff on the highway. You might be prosecuted for that, even though it was absolutely, your intent was to make the stuff go to a safe place. So unfortunately, doing business today is a little bit more risky than it used to be. The best thing you can do is have good protocols in place and have good risk management, which unfortunately today again includes avoiding criminal liability as well as obviously handling your civil liability. Actus reus is we also want to have the act. So you have to have two pieces. You have to have the intent and you have to have the act itself. Capacity, we're going to see this term capacity, we're going to go through it quickly in the future, but basically you have to be with the program, as we say, in order to be held responsible for your criminal acts. But we're going to use the same analysis when we talk about entering into a contract. You have to have capacity for a contract, you have to have capacity to enter into a will, and so forth. So we're going to talk about capacity. Criminal capacity is a little bit different, though, because it tends to go lower. Basically, anyone under 18, the Supreme Court has decided cannot get the death penalty. So you may have some very deserving teenagers, but if they're under 18, they cannot get the death penalty. It doesn't mean they can't get life in prison, but they cannot get the death penalty. That is under the constitutional prohibition against cruel and unusual punishment. So we have children under 7 presumed to be incapable of forming the intent to commit a crime. Generally speaking, we used to use 14, 16, something like that in terms of being responsible as an adult. As many of you know from the different TV shows, that is actually true in real life. There's a lot of social pressure when a 16-year-old or a 15-year-old commits a heinous crime to have them prosecuted as an adult rather than as a child. And so I'm not sure all the different pluses and minuses that in the community. It's just that is certainly one of the pressures that the district attorneys deal with. But generally speaking, the states make the rules by state, but again, the Supreme Court got involved with this issue of under 18 for the death penalty. Other than that, there's not a lot of federal rules, so it's state by state as to whether you prosecute someone as a juvenile or not. But the trend has been towards lowering those ages, making teenagers especially responsible as adults. In terms of corporations, as much as we'd like, you cannot put a corporation in jail. So we need to find somebody who's actually involved. And again, this is where we're seeing a trend towards making it more exposed for business leaders, presidents of businesses, managers of certain units. Type of inquiry is a hypothetical, is there was a deliberate dump of dangerous chemicals into a stream. Well, who ordered that? Well, the federal investigators from the Environmental Protection Agency, Department of Justice get involved, and they'll go out to the manager of that site and they'll say, okay, we're going to put you in jail, but maybe you'll get off if you tell us who told you to dump the stuff in the river. And he says, oh, that's easy, I'm my regional vice president. So they say, okay, we give you immunity, we're going to go prosecute your regional vice president. They go to him, they put him in jail, they pressure him, they try and get to the president of the company. So this is turning in a lot. Again, you see this in some television shows. Unfortunately, that's not fiction. That's what's happening more and more. Yes, sir?
So how does this apply to the Wells Fargo issue that's going on right now?
He doesn't have any immunity at this point, but he has not been criminally prosecuted. So the issue would be if some of the lower level people, if there is a criminal prosecution, as far as I know, there is not one presently. Wells Fargo self-reported and said, we've just fired up to 5,300 people. We uncovered this horrible event. And like I said, the president tried to hang in for a couple of weeks, and that didn't turn out too well. But many people have said there will be a criminal prosecution. It'll probably go the way I just described. They're going to go to the low-level people, tellers and people like that. And to give you a reference point, I attended a lecture about 3 months ago about a woman who could be any one of you sitting in this classroom. She got out of a first-class accounting program. She was an accountant for a corporation, and something went horribly wrong. And she was the absolute junior person, absolutely no decision making, and she went to jail. She spent, I think, 18 months in jail, and she's unhirable. She was working for a company after she left the job where she got the exposure, and as soon as she got criminally prosecuted, they laid her off, and they were in tears and said, you're a great employee, and we take your word that you didn't intend to do it, but we just can't, there's too much liability. And then she went to jail anyway, so 18 months in jail kind of disrupts your career path. And she had little kids, and so it's a very, very compelling story where personally I think she could have argued differently, but it was real interesting because she related this. She said that there was another accountant involved with her in the deal, and they said, we'll give you the same deal, basically 18 months. And he fought it and ended up getting sentenced to 7 years or something like that. And so she thought taking the 18 months made a lot of sense. The way she tells the story, the vice president never was criminally prosecuted in that cycle. And she says the vice president's guy, but she said there's like no emails that connect him. There's nothing that connects him. And so she said, she had realized all the way back at the beginning when she was too green that, when you have people and you disagree. First of all, the term I use, and pardon me, I know you guys, some of you probably have kids, is spider sense, Spider-Man. He says, my spider sense is going off and something's going wrong. Let your spider sense guide you. I mean, if it doesn't sound right, it doesn't pass the smell test, don't do it. It's much better to be fired. Most of the time, you're not going to end up living under a bridge. A lot of people say, oh, it's easy for you to say, all that. Well, we'll talk some more about that. But it's interesting because in her case, one guy goes 7 years, she got 18 months, and the VP got nothing. And I just think that really stinks. But they didn't have any way. There was no documented evidence to tie him to the decisions, even though he gave all the direction. Yes, sir.
Do universities have any corporate liability, or does universities fall under corporate liability at all?
Yes, there is, and of course the best example of this, sadly, is the Penn State case. And in fact, I just heard that there's the Penn State quarterback from the time of the Sandusky scandal has just filed a civil lawsuit against Penn State University for like $1 million, like literally in the last few days. I just saw it in the news coverage over the weekend, as a matter of fact. And so certainly if you have a scandal like that, and there was a host of people who had to know about it, then it's a very, very serious situation. And a lot of different things can happen about that. Also, I mean, there are so many different pieces to it. Like, as you know, ITT Tech just went out of business. Argosy, another for-profit, went out of business a couple of years ago. There are some potential criminal prosecutions in there where if students are told, we're going to let you get all this federal loan money, this is why the feds are involved, we're going to let you get all this federal loan money, but you really don't have any realistic chance of getting a job. But gee, you know, you can pretend to go to school, and you can pretend to do whatever, and we're going to give you real money because it's not our money, it's federal money. That gets pretty close. So there, watch those. Argosy, I don't recall whether any criminal prosecutions, but it will be interesting to see over the next 6 months or so to see if there's any prosecution there. But the for-profits got hammered because they did a hard sell on people, and you get into, you mentioned fraud, you get into fraud issues, and that can be criminal and civil. So, good question, yeah, but it's definitely, you know, we have to play by the same rules as everybody else. And so the same type of thing that can be against a for-profit business can be brought against a non-profit business. It's just that a lot of times that doesn't necessarily happen because we're not under that pressure to pump the stock. There is no stock by definition. A charitable organization like this has no stock. So without having a stock market incentive and stuff like that. We'll mention though, something you might want to look up, and I think they were based here in Texas, is it's the Alamo Foundation. I think it was, I forget her first name, I think it was Susan and Tony Alamo. It was one of these religiously affiliated charitable organizations, and he ended up going to jail, and I think both of them ended up, the husband and wife, both ended up going to jail, and that was a missionary operation similar to, you know, a lot of different operations like that. I don't want to mention any other names, but, you know, that kind of stuff. So it's pretty interesting. Criminal prosecution, we have a lot of different defenses. Good business defense on entrapment. Everybody familiar with Back to the Future? That really cool car. Everybody remember what the name of the car was?
DeLorean.
It's a DeLorean, absolutely. John DeLorean is an auto industry executive, accredited with a lot of good stuff in the auto industry. Decides to start his own car. Comes up with his little cute little car with a stainless steel skin. It wasn't solid stainless steel, but it had a stainless steel wrapper on a fiberglass shell. And only 50 are made. Well, it turns out it's a hard business, and he's in financial trouble. So the FBI calls him up. Of course, they don't say it's the FBI. They say, hey, it's Buddy Jack here. And they tell him that if he will deliver cocaine, they'll give him $1 million. So DeLorean, obviously a genius, agrees to this deal. And of course, he goes and shows up, and they put handcuffs on him instead of giving him $1 million. And so he alleged entrapment, and he gets off completely on the basis of entrapment, that, you know, they created a crime for him to participate in. But I mean, he should have been jailed on just stupidity by himself. But I mean, it's a true story, and that's really heavy-duty entrapment. Again, you see a lot of TV crime shows, you hear concerns about entrapment and people getting off. The other piece of that, of course, is what we call the exclusionary rule. And then one of the big discussions about immunities in the news right now is the person who designed this private service system of Clinton was given immunity, and the people in Congress are saying, whoa, what did we get for immunity? Because immunity is usually the person gets immunity in exchange for ratting out the next level up. And they're saying they gave this guy immunity and got nothing for it, in which case, why did the guy get immunity? So it's pretty interesting. And we have all sorts of live action stuff going on now. All right, one of the ones we hear about occasionally, again, especially movies and television, is insanity. Now here's the deal. You have to really, really be insane. So if you're just a little off, insanity's not going to get you off the track. You have to be totally disconnected from reality in order to get off on insanity. You cannot comprehend the difference between right and wrong. Now what happens is, a lot of times the movies and television is presented as, oh, you know, I'll just go to jail for a couple of years, and you know, I'll go to the insane asylum instead of going to prison, and then I'll get out, and I'll all of a sudden pretend to be well, and I'll get out. Well, the problem with that scenario is that, first of all, if you had a choice between prison and an insane asylum, take prison. Part one. Part two is, you want to make sure that you understand what's going to happen, because you may be over at the insane asylum for 2 years. They say you're okay you go stand trial at that point. Now, the only advantage might be is your witnesses might die or their memories may fade. You might have a better chance over at the courthouse. But yeah, insanity is not a get out of jail free card. Now, the second part is intoxication. Now, this used to be a great drunk driving offense. So you get, you know, plastered, you get in your car, you run somebody over, or kill somebody in an auto accident, and they would say, the defense would say, the person had no mens rea. They could not have formed the intent to commit a crime because they were too drunk. They were not with the program. And so this has been contemplated by the law. The law's been changed in, I think, all 50 states to say if you intentionally got drunk, you just went to party, you didn't make arrangements to take Uber home or a cab or whatever, or do like my friends do, is designate Dr. Shine as the designated driver. Very easy, I have no desire to drink. It's, I usually, the person drives home on New Year's Eve and stuff like that. But if you don't make that plan, you intended whatever happened after that. So it's implied consent to make a decision, form the intent. So that's how people are now being criminally prosecuted for drunk driving. But it's a little bit of a stretch, but it's being done state by state.
I think that's how they prosecuted that lady with the stiletto. She was professor for UMA. She was intoxicated.
Yeah.
Used the stiletto shoe case or whatever.
Oh, I love that case, yeah.
It's so crazy.
The stiletto shoe case where she killed somebody by stomping on her with her stilettos. Or she used it like a hammer. She hammered them with the, people say those things look dangerous. Well, apparently they were at least once. Okay, one of the things we want you to focus on in this chapter is that you should make note of the amendments and time in which each amendment, because these are great multiple choice questions. Big hint, folks. Okay. So, but most of you know, again, from high school civics and watching television, Fourth Amendment requires states have legally obtained probable cause to search and seize persons or personal property. It's your Fourth Amendment rights. Fifth Amendment. Boy, this is one we've heard a lot of. How many people you know in politics in Washington have taken the Fifth Amendment in the last couple of years? Yep, a whole bunch. Okay, Fifth Amendment, right of self-incrimination. Indictment by grand jury for capital infamous offenses. And prohibits double jeopardy, we mentioned a minute ago. Miranda. Most of you know Miranda by heart because you've seen it on television so often. And they don't even bother to recite it on television anymore. We just say, yeah, we gave it Miranda rights. So they don't even fool with it anymore. But it includes the rights in the Fifth and Sixth Amendment. Anything you say can and will be used against you. And you have a right to have, a Sixth Amendment right to have an attorney appointed if you cannot afford one. That is based on the right of counsel. The argument was, if you don't have any money, the right of counsel is kind of an illusory offer because you don't have a right, you don't have enough money to hire an attorney. So it's pretty interesting. Businesses do not have the same constitutional protections as individuals. That's important to keep in mind. We have various things. Prosecutors can't comment on the failure of the defendant to testify. You cannot be forced to testify in a criminal trial, and you see this many times in television shows and stuff where people don't take the stand. In other cases, it's very dramatic. The person says, "No, I'm innocent. I've got to get out there and do that." One of the things I appreciate, folks, is that criminal defense attorneys don't work for free, and especially if you see a case where it's like a white-collar crime or a high-level individual. These people do exactly what their attorneys tell them to do. Anything you see to the contrary in television movies is just nonsense. I mean, why would you pay an attorney $25,000 or $30,000 to get you off, and then say to the attorney, "Shut up, I'm going to admit guilt"? I mean, nah, I don't think so. Not going to happen. Fifth Amendment, they've decided being forced to take a breathalyzer or blood test on a drunk driving arrest is not a violation of the Fifth Amendment. Excessive bail, and as we mentioned, death penalty for under 18, under the Eighth Amendment for cruel and unusual punishment. Sixth Amendment right to jury trial, assistance to counsel, right to confront adverse witnesses. Last one directly tied to the colonial period, because the British would prosecute people without the witnesses being present. So our colonial fathers, being aware of this, make sure that was built into the Bill of Rights, first 10 amendments to the U.S. Constitution.